Mr. Trivedi.
Yes, my lady. I believe we paused at my lord's question in regards to paragraph 66 and the distinction between why there's automatic liability on the part of the HCEO but not the creditor under the remit of under the construction of paragraph 66. And I think we were going to come on to Bone.
You are absolutely right. That was the precise point at which we stopped. And I would find it helpful, if you wouldn't mind, if you could just give us a preview of your answer to the question before we delve into Bone, because then I'll know what to be looking for.
Right, so in terms of Bone, the argument is that the case before your lordship is a different kettle of fish, put it that way, in terms of the creditor. In Bone, and I'll take you to the relevant section in a moment, the argument why there's automatic liability and the reasoning towards it was because of where the enforcement power under the writ was directed to. In that case, it was directed to the HCEO and not to the enforcement agent directly. Whereas in this case, it's not directed towards the creditor at all.
In both cases, it's the agent who breaches.
Yes, that's right.
The schedule.
That's correct. So in terms of Bone, it's page 670 of the authorities bundle, 670. So this was the paragraph that was referred to by my learned friend. It was argued that Mr. Williamson could not in any way be liable as respects the actions of Mr. Brown, who was the enforcement agent under Schedule 12, because Mr. Williamson himself could not use the Schedule 12 procedure. It's true that Mr. Williamson could not use the Schedule 12 procedure, but that is irrelevant because he had the power which he used to authorize Mr. Brown to use it. Mr. Brown had no independent power to use Schedule 12. That is a straightforward consequence of the statutory scheme and does not depend on any appeals to the general principles of the law of agency. We come further on, paragraph 94, which is on page 71. And here the court states that the clue to the analysis seems to lie in the titles conferred. The primary obligation for enforcement is on the HCEO, to whom the writ is addressed. The HCEA is an agent, not a principal. The act is agent for the HCEO when using Schedule 12 procedure to effect enforcement. The agent derives their powers from the authority conferred upon them by the HCEO.
How does that analysis help us in the circumstances of this case where there is no HCEO?
The argument is the idea that there's automatic or joint or several liability on the part of the creditor in this case. That argument, this case does not lend assistance to that argument because in this case the reasoning for why there was joint or several liability was because the primary obligation for enforcement in that case was the HCEO, to whom the writ was directed, who had the enforcement power, who could confer it onto the enforcement agent. Here, the warrant isn't directed to the creditor. The creditor does not have enforcement powers, and the only person who does is the enforcement agent. He's the only one who has the enforcement power under the warrant, and he's the only one who can exercise that enforcement power. The creditor can't.
Well, to be sure, that's not in dispute, that the creditor can't exercise the enforcement power. And because there's no HCEO, the only person who can is the agent. So that much is not in dispute. But how's that relevant so far as the interpretation of paragraph 66 5b is concerned, where you've got the related party, if not an enforcement agent, and then you've got the creditor.
The relevance in my submission comes from the fact that under subparagraph 566, paragraph 66, there isn't joint several liability on the part of the creditor. There's a distinction between the way in which one approaches the HCEO as opposed to the creditor. My other friend used Bone to demonstrate that there's joint several liability in that because there is joint several liability on the part of the HCO because Bone says there is. Therefore, to make it consistent with that, it must be the case that the creditor must hold joint and several liability as well. The point of using Bone is to demonstrate that the analysis in Bone leading to that conclusion that there's joint and several liability does not lend of itself of any assistance to the scenario where there's a creditor involved, and they are the ones as opposed that are being sought after in the claim. So that therefore there isn't, in my submission, joint and several liability on that argument.
Really, all you're saying, although you're relying on Bone, is that the paragraph 66(6)(a) is of a different nature to B, that a person on whom the enforcement power is conferred is essentially and totally different from the creditor. That's what you're saying.
Yes, that's the first point. To add to that point is therefore there must be a different analysis to be given towards a creditor. Of course, I've not had the opportunity yet to run through my submissions from the point I would like yet, but that is the end result. Bone doesn't assist in that analysis, is my submission. Bone has been relied upon. They would not assist in the analysis of whether or not causation is required. It doesn't lend itself any support to the appellant. It does show that creditor does not have any enforcement powers, and that it does not confer any upon the enforcement agent. There is no agency relationship between the creditor and the enforcement agent.
Personally, I gain relatively little assistance from that. It's just like saying, therefore, one can see it's natural and proper, perhaps, that a 5B, when referring to a related party, refers to 6A, person with the enforcement power. But it's more difficult to see that it includes the creditor. But that is the definition of a related party for the purposes of 5B. So I'm not helped very much by that.
It would also assist, those who jump about slightly, is the argument I've raised in respect of agency in my skeleton.
Mm-hmm.
It's that paragraph 33 onwards. This was also raised in the Bone case. This very same argument, but in my submission, is much more critical and applicable here than it was in the end in Bone and Williamson. And I do make reference to Bowson and Reynolds and Chitty, which I'll come on to in a moment. But the simple reason I have submitted that paragraph 33 is why the enforcement agent cannot have been an agent for the respondent as creditor is because, as I put there, X as principal can only grant Y as agent the same power X has for Y to act on X's behalf. So the power that can only be granted to an agent is the same power that was held by the principal.
Yes, but in effect what you're saying is that a related party should only cover 6A and not 6B.
Well, what I am submitting is that whilst the related party is set out there as creditor, there has to be something other than simply there being a creditor in existence for there to be liability. So the inference being drawn is, as my friend has tried to argue, a case of vicarious liability or agency. There isn't one.
You're saying there isn't one in relation to creditor at all. You can see where you're coming from in little a, and but in order for a related person to also encompass a creditor, or for that the fact that related party includes creditor for the purposes of 5B, where there is no agency, because you say there is none, then you need more in 5B.
Absolutely.
That is your case in a
That's
nutshell.
Right. That's right.
But there aren't any words to that effect.
There is.
On the question of agency, could we look at what Lady Justice Andrews said in Bone at paragraph 98, please? Because this is page 672 in the bundle of authorities.
Yes.
And towards the end of that paragraph, Lady Justice Andrews says, in general, you cannot authorise an agent to do something you cannot do yourself, and that's the principle you rely upon. But she goes on though there are exceptions, for example, where the agent has a necessary qualification that the principal does not possess. And that was not true in that case, but it is true in this case, isn't it? Because on your own submission, the agent has the enforcement power and the creditor does not. And since my Lord Justice Phillips agreed with both judgments, that point has the authority of a majority of the members of the court.
I'll just take a moment to just digest that particular section at the bottom, my Lord. Thank you. My Lord, with no disrespect to the judge in the case, the only thing I can say is that the particular sections of the law appear not to have been considered as I refer to Bousted and Chitty, which both raise that same point.
But Bousted says there can be exceptions as well.
I have not seen anything to that.
Well, let's look at it.
I believe it's page 693 of the bundle.
It's the penultimate sentence on the page. As with most principles, there are likely also to be some exceptional cases. And the footnote refers to Article 6, which we don't have. But Bousted seems to accept that there can be exceptions.
That might be the case. Well, what I would submit is this is one of those exceptional cases where we have a creditor who cannot do anything under Schedule 12, who may not even know what Schedule 12 actually is. How can a principal direct someone to do something where they themselves don't know what they're exactly doing, other than you need to get this money back for me by selling their goods?
Can you help me on that? Because I'm a bit puzzled by the idea that the creditor's has got no idea about this. Because the creditor, in these circumstances, has put the enforcement procedure in motion. The creditor has obtained the warrant of control. So, and the warrant of control on its face talks about the enforcement agent. So how can the creditor not know anything about this?
They may or may not know whether, the existence or the application of Schedule 12, the details of Schedule 12, which is the enforcement power itself, to take control of goods and sell them under that schedule. The detailed provisions themselves, they will not know of.
Well, I'm sure you're right about that. I'm sure most creditors would be completely ignorant of the details of Schedule 12. But why does that matter? Because surely what matters is that the creditor knows and intends that the enforcement agent is enforcing goods against the goods on their behalf. That's the whole object of the procedure.
It is, but they would not know if there's been a breach or otherwise. They would know. They can't control their powers. They wouldn't know how they're being exercised, and whether it's or otherwise. Potentially,
you say the creditor can't exercise any control. What's your answer to Mr. Kessler's point that they can exercise control through contract?
Well, they may be able to. We see in this case that's not the situation. We have a contract between Marston's and the HMCTS. I appreciate that's a possibility, but it's not the case in every situation. That's the key point here. We have different types of creditors. If there's going to be a blanket position in the law, then it cannot be the case that in every scenario there's a contract between creditor and agent. In this case, there isn't, and there may not be between a private individual. Most likely wouldn't be between a private individual and an enforcement agent either. If there's going to be a blanket position in the law, then there ought to be analysis of, or to be acceptance of the fact that there could be more than one type of creditor and more than one type of contract. I can't see how my learned friends point that they can control through a contract means that in every scenario that's what will happen.
And as you say, in the case of private individuals, it's very unlikely to happen.
Very unlikely to happen. And that goes back to understand the Court of Appeal's function, but it's important to realise that the effect this has on creditors across the board, not just the Ministry of Justice, but how this affects the normal individual in the County Court of Northampton, for example, who just simply wants their money back. And if the enforcement agent does something wrong, which the enforcement agent who has the qualification will know it's wrong, how can a creditor be held responsible for that? Unless there is some causation requirement. And that's where I say paragraph 66 appears. I appreciate the wording does not help. It appears there is something missing there that Parliament have not clearly picked up on. But there's no, on the construction of it, there's no harm in there being a causation requirement. If there is a reasonable belief defence, that appears to apply more to the enforcement agent. But if there is a qualm with the creditor alone, there's always alternative means of claims that proceedings can be brought for that.
How do you say it works? The court has before them a claim against the creditor and makes an assessment that the creditor had in some way caused or contributed to the damage, or caused and contributed to the breach which led to the damage. But what does the court then do? What's its approach?
In terms of liability between the two. That is, I have addressed that. In the cause of contribute section, paragraph 41 of my skeleton. No doubt the courts have in the past dealt with causation in many different ways in terms of apportioning liability. So the same process would apply. So I've set out here that the judge can apportion liability on the evidence or assign liability equally. So in a scenario where it's difficult to assign liability precisely, there is always the option of apportioning that liability equally. It depends on the state of the evidence.
But what if only the creditor, as in this case, is before the court?
Of just the creditor alone. But that case would in that case, obviously, the same analysis would apply, but obviously the percentage of liability that ought to be attached to that creditor would be assigned, depending again on what the evidence says. It must be both parties don't have to necessarily be the enforcement agent and the creditor.
I may have misunderstood what you were submitting, but are you saying that the court has a free discretion to apportion liability between the agent and the creditor?
Referring to Clark and Lindsell, the same principles that would apply in tort could apply and ought to apply in these circumstances as well.
Which tortious principles are you referring to?
So I refer here to Clark and Lindsell. If I could just pull that up, my lord, one moment. So page 706 of the bundle, authorities bundle. Right at the bottom, just the heading there, material contribution to damage, 233. The claimant does not have to prove that the defendant's breach of their duty was solely in the main cause of this damage, provided he can demonstrate that he made a material contribution to it. My submission that could apply.
Yeah, well, that gets us into bodies and castings, which is a notoriously difficult area of the law.
Yeah, it wouldn't be as complicated as that, my lord, in this scenario. But that's one option. And if we go further to 708, where it talks about multiple tort fees as a contribution to the risk, it sets out right at the beginning: the possibility that the claimant's damage has been caused by more than one potential defendant is not uncommon. A judge must reach a conclusion of liability and should not dismiss the possibility that both or all parties are responsible unless he can decide which of them is solely responsible. Where there is no evidence to indicate the real proportion, responsibility will normally be assigned equally.
Can you give us an example of situation where you would say a creditor would have caused or contributed to the loss?
Yes, my lord. Footnote 11 in my skeleton makes reference to things such as a judgment that's been irregularly or fraudulently obtained, maliciously taking out execution for the full amount when part of it has been paid. What has been raised in lower court proceedings as well, that there's incorrect information given by the creditor to the enforcement agent. So
Well, how would that work? Because if it was incorrect information given to the enforcement agent, he would have a reasonable belief.
He would. I appreciate there's difficulty in terms of the defence that plays to the bottom of paragraph 66, but my submission there is that's geared more towards the enforcement agent's own liability, but to the extent that it would wipe out the entire liability, the claimant would have to consider whether or not to bring a separate type of action, whether that's a Part 7 claim or otherwise, in order to seek its loss against the creditor directly.
But yes, the point is that we can't identify situations where, sensible situations where the creditor has caused or contributed and there's still liability, then it suggests that your analysis doesn't work.
There could be situations, my lord, where both there isn't a reasonable belief. Both could be at fault. Both could jointly have done something wrong by way of a breach of Schedule 12 that he's aware of potentially. The enforcement agent. It's not my submission outside of the realm of possibility.
But as you put it to us, in almost most cases, the creditor's not going to know what's going on the ground on the day when the enforcement agent goes to the property and seizes or clamps or whatever he does. Are they? I mean, it's not a realistic situation.
The creditor wouldn't necessarily know, but I believe the question was scenarios where the creditor does something
causes or contributes to the breach.
Well, those are some of the examples I gave, my lord. There are circumstances where it could happen.
I think you said, well, judgment is obtained maliciously, I think you said.
That's one of them.
How would that lead to a breach of Schedule 12?
Because if then the enforcement agent goes and actually executes it and takes the goods, then he ought not to take the goods. That's a breach of Schedule 12. The reason behind it is because the judgment was irregularly obtained.
But surely it's a valid and enforceable judgment unless and until it's set aside.
The judgment may be, but because it's based, well, I see the point, my lord, there. The RBB could still be a breach of Schedule 12 if it's
but how so? Because there's a lot of case law on formal validity of judgments, and without getting into detail, the basic proposition is the judgment or order of the court is valid and effective unless and until it's set aside. It may have been irregularly obtained, and it may be set aside, but unless and until that happens, then everybody's entitled to act on the face of the judgment, aren't they? Or the order.
Well, I'll move on from that point.
All right. But if you're moving on, could I ask a related question to the one that my lord was asking, which is, and it may be convenient to go back to paragraph 66, which is tab 6, page 82 in the authorities bundle, because I would be grateful for your assistance on the logic of the way in which subparagraph 8 is drafted. Because what that tells us is that subparagraph 5b does not apply where the enforcement agent acted in reasonable belief. And what that tells us is not just that the enforcement agent is protected, but also the related party is protected. Even if, following on from some of your hypotheses, the related party has behaved in a blameworthy way. Now, what's the logic of that on your submission?
Nothing further I can add to that, my lord, other than what I submitted, which is that if there was, if if that defence absolved the creditor or was going to absolve the creditor, the only other remit for the debtor would be a Part 7 action directly against the creditor to avoid that particular provision. Can't get away from that.
Thank you.
With the court's permission, I will return back now to at least somewhat near the beginning to just guide through, just to make sure I haven't left anything out. I wanted to set out some of the law firstly. My other friends set out the 2007 Act. There's some sections just so that the court is aware of how it operates, at least in respect of the respondents, so in support of the respondent's position. Paragraph 19 of my skeleton deals with this onwards. I'll short circuit most of that where we've already discussed the points. We already know that Section 62 applies where a warrant confers power to use the Procedure Act schedule. We know the warrant confers that power. And that power conferred by the warrant is to recover a sum of money, and it's only exercised while using Schedule 12. We also know that Section 63 confirms that an individual may act as an enforcement agent if he acts under a certificate. In this case, we're not too worried about the other types of ways in which an enforcement agent can act, where he's exempt to act in the presence or under the direction of a person to which the above applies. Although there's a reference there to relative exemptions such as individual acting in the course of his duty as a constable or officer of HMRC or a court officer, which was a tension in bone, but not too much of a worry in this case, and an officer of a government department. And the key provision, which I'll come on to in a moment in my submission, is Section 64 confirms that a certificate may be issued by a judge of the county court. This will come on to the point I raised about the enforcement agent being an officer of the court, a self-employed certificated agent, because they are certificated, in my submission, regulated by the county court. In the first instance, there may be other regulatory bodies, but the county court issues certificates and also handles complaints and also considers that the bond to be that the enforcement agent should hold. So I'll come on to that.
I take that point, but can you help me on this? That might suggest that the certificated enforcement agent is an officer of the county court, but how does it make the enforcement agent an officer of the magistrate's court, which issues the warrant?
Although I appreciate there would be a necessary distinction between the two, because we know it's a court that's issued the certificate. So they are officer of a court. I appreciate it's not the magistrate's court that issues the certificate. They are an officer of the court in that sense. They are still an officer of a court. So, my lord, I don't believe the distinction takes matters anywhere necessarily. In my submission, there's still an officer of the court. In this case, the warrant was issued by the magistrate's court. The enforcement agent certificate was issued by the county court. I don't believe the distinction affects my analysis.
Well, I appreciate that it might not be determinative, but why do you say it's not relevant? Because as I understand your argument, and maybe I've misunderstood, but I thought the point you were making is that the enforcement agent could not be the agent of the creditor because the enforcement agent is an officer of the court. But how does that work if the enforcement agent is not an officer of the court which is actually enforcing the fine?
Because the purpose behind at least some of my learned friends' arguments around the supervisory role, if the creditor is not the person or the entity that oversees the actions of the enforcement agent, then who else could it be? we can see that it's the county court that oversees self-employed certificated agents and their actions, because they are the ones that issue certificate, they are the ones that handle the complaints against them, including the awarding of damages by way of the returning of the £10,000 bond to whoever to the aggrieved debtor.
So you're saying enforcement of a fine in the magistrate's court inevitably is going to be dealt with by an enforcement agent whose credentials, etc., are certified by the county court.
Absolutely.
But that is just because that is the procedure in relation to certification and bonds, etc. But that doesn't make that person any less an officer of the court. It's just that the county court has the duties in relation to certification, bonds, and the like.
I appreciate that, my lady. I deal with this paragraph 20 onwards of my skeleton as to what those regulations actually say, and I don't think I need to take you all through the regulation in detail, set out in summary format there. So the county court issues a certificate for a person to become an enforcement agent. They have to be a fit and proper person to hold the certificate. They must possess sufficient knowledge of the law and procedure. They become further forward down. Regulation 4 requires the county court to maintain a list of certificated agents. So the county court, if they wanted to, they could find out who their self-certificated agents actually are on the ground actually doing the work. They may not necessarily know who's got the precise warrant in their possession, but they would have a list of who these people that have been certificated are. They provide for a bond securing a security bond totaling £10,000. Well, they need to satisfy the judge that the security of the amount is subsisting. And Regulation 6.2 requires security to be retained. And quite interestingly, I've put there that the security has to be retained once a certificate is issued for the purpose of securing the certificated person's duties as an enforcement agent and to secure payment of costs incurred in investigating a complaint made to the county court against the enforcement agent. So in my submission, that lends the argument towards the enforcement agent being an officer of the court more than anything else. We also have Lord Legate who's confirmed that as well in CES and Marston, that an enforcement agent is an officer of the court.
As I understood Mr. Kessler's argument, he wasn't too bothered about whether an enforcement agent was or was not an officer of the court. His submission was that the two things were not mutually exclusive. Do you say that they are?
My initial submission was that if you're an officer of the court, you're not an agent of the creditor.
So your submission is they're mutually exclusive?
Absolutely. That was my initial submission. I appreciate what CS and Marston says about that, but in the context of writs of control. In the alternative to that, I do have my submissions already made, but also to be made in terms of agency and vicarious liability. So to the extent they are an officer of the court, they are not, for the reasons I give, vicariously liable for creditors, not vicariously liable for the actions of enforcement agents, nor are they an agent of the creditor either. So to the extent that they are not considered to be mutually exclusive, there is an alternative argument as to why they are not the agent, enforcement agents, not the agent of the creditor.
And what's your submission about CES in that regard?
Well, CES dealt with the point about high court writs of control. It did, I appreciate it, it does say that the office, that the enforcement agent is an officer of the court. I appreciate I can't really get away from what CS and Marston does say about what it does say about enforcement officers. In my submission, it doesn't really touch on the point about paragraph 66, as the court is aware. It didn't deal with that point specifically. It did not deal with the relationship between a creditor and an enforcement agent, let alone a relationship between a HCO and the creditor, for example, the precise relationship between HCO and an enforcement agent. So in my submission, it doesn't touch on the point that the court is concerned with today directly. and the point wasn't ventilated in an argument in that case either. Just a quick point to note for the court as well in respect of the certification regulations. That paragraph 22, it's also confirmed that the judge in the county court may order the enforcement agent to have fulfilled conditions as to training. They can even suspend the certificate pending any training or actions being undertaken. So they do have a supervisory role to play there. They are the ones certificating the agents, and they are the ones making sure that they are fully fit and trained to be able to perform their functions.
Where does all this take us? Because, for example, solicitors are officers of the court, and there are regulations, and they are a supervised profession, but they can still act as agents for their client.
They can, I appreciate that. Some alternative argument is there isn't an agency relationship here in any event for the reasons I've given between the creditor and the enforcement agent, particularly in the context of this case, but generally speaking as well, given the definition of an enforcement power and to whom it's conferred. But I know we've already have dealt with that point. Last couple of points on assumption of on ground one, apologies, is vicarious liability and assumption of responsibility. And just two quick points to make about that. In terms of vicarious liability, my learned friend in his skeleton argument set out a test.
I'm not sure he's really pursuing that point.
That's fine then. In my submission,
Whereas he is definitely pursuing assumption of responsibility.
yes, which I'll come on to. In short, then, my skeleton argument deals with it anyway. There's no control on the part of the creditor over the actions of an enforcement agent, which we've already dealt with as well. Control is a key factor. In actual fact, when it talks about independent contractors, the point is more emphasised there in Clark and Linsell, that in very rare situations that there would be a vicarious liability attached for the actions of an independent, self-employed contractor.
Well, I take that point, but Mr. Kessler's argument is this is the statutory scheme, so it's not based upon any independent argument, as I understand it, as a vicarious liability. I think what he was trying to say in the skeleton was, if you think about vicarious liability, the statutory scheme is not surprising, but he's not relying upon it as an independent basis, whereas he does say that assumption of responsibility is an independent basis.
In that case, we can move straight to assumption of responsibility, my lord. Deal with this at paragraph 40 of my skeleton. The first point to make is, I accept what the national guidance says, but it is non-binding. On the stretch of the Ministry of Justice, they appear to, well, they accept that there's obviously an error in terms of...
On its face, it says it's not legally binding.
Yes.
But before we get into question of what effect one gives it, if any, what do you say it means? Because when we look at paragraph 7, it says that creditors are responsible and accountable for the enforcement agents acting on their behalf. What do you say that means?
Well, may I ask for the page number in the authorities bundle?
It's 925, tab 48, 925.
The tab 14, Mother, did you say? Oh, apologies.
48.
48. Thank you. Yes. And it was paragraph
7, page 925.
believe the court's point first and foremost that was raised earlier is quite correct, that the definition of creditors includes the large creditors. That's point number one. I appreciate what it does say at 7. It does say creditors should remember that enforcement agents acting on their behalf, that ultimately they are responsible, accountable for the enforcement agent acting on their behalf. But as I say, it's a non-binding guidance.
Before we get into the questions of its status and effect, the first question is, what does paragraph 7 mean? Now, Mr. Kessler's submission is very clear. He says you can only be responsible and accountable if you're liable. And my question is simply, do you have any alternative interpretation to offer us?
There isn't an alternative interpretation to the wording that's set out therein, my lord.
So you accept Mr. Kessler's contentions to the meaning of paragraph 7, but your submission is that it doesn't displace the statutory, and we have to look at what the statute says.
Absolutely.
But would you accept that it's a necessary consequence of your submissions that paragraph 7 is wrong?
That's correct.
Yeah.
That's what I was coming on to.
Is that not somewhat surprising?
In the sense that it's being resolved from, my lord?
Well, it's surprising whichever way up you hold it. Isn't it?
Mr. Justice, it's been the position that it's an error and it's non-binding and doesn't represent the position correctly at law. That's all I can really say about paragraph 7.
All right.
Well, forgive me, I just wonder if you're accepting a little bit too much there. And we're talking here about large organisations. It said responsible and accountable. Well, what's the difference between responsible and accountable? What do each of those phrases mean?
No, except that there is ambiguity in its wording. I appreciate that.
And then it goes on at 8. They should act proportionately. Well, what exactly are we saying here? Is there a liability if you don't act proportionately? I don't think there is there? And
no.
Must notify the enforcement agent of all payments received, etc. None of these matters, it seems to me, on the face of it. 10. Creditors have a responsibility. I mean, these don't seem to me to be referring to legal responsibility in the sense of legal liabilities. These are standards of conduct of the sort that might be dealt with by an ombudsman. I think if it meant to say that you are legally liable, would it not say so?
Thank you, my lord. I see that. It doesn't assist towards the interpretation of paragraph 66. I appreciate that it does say on the face that creditors should remember that enforcement agents acting on their behalf, but it doesn't assist in the interpretation of paragraph 66. And actually, I believe in Benyon, it's confirmed that when looking at guidance such as this, it might be worth just properly putting Benyon up, because the court's way in which to interpret this document. Page 841 onwards. If that's might not be the section.
Forgive me, but doesn't this mean that creditors are responsible and accountable for their enforcement agents acting in accordance with these national standards? Not that you are liable if they breach Schedule 12. That seems to me to be a very different thing. When these matters go well beyond, and actually don't specifically deal with breaching Schedule 12, do they?
Yes, my lord. It's open-ended in terms of what it could mean, and it appears to be in relation to you should comply with this guidance, as opposed to you should comply with paragraph 66.
Well, no, you should ensure that the agents comply with the guidance. Is what it's saying, isn't it?
Yes. Enforcement agents.
Yes. Look, it's not for me to say concluded view, but I read this as giving guidance as to the way you should deal with your powers, with the enforcement powers, and what it's saying is that these are the standards, and you're responsible and accountable for ensuring that the agents comply with those standards.
Yes, my lord, and it doesn't exactly. It's a document that is vague. It's a document that doesn't direct the enforcement agent to any particular legal legislation, for example. And as I said, page 845, that's the page I wanted to refer to in the authorities bundle. Yep. It confirms that guidance by a public authority may be persuasive as to the legal meaning of enactment depending on the quality of the reasoning at 24.17. In my submission, this doesn't assist at all in that respect. On the face of it, I can't get away from the fact that it says in literal meaning that the creditor is acting on behalf of the enforcement agent. In terms of the interpretation of paragraph 66, it doesn't take the court anywhere.
Can I just ask you a slightly different question? Am I right in understanding that although dating from April 2014, this is still the current version of the national standards?
As far as I'm aware, yes.
Are you able to draw to our attention any public statement of policy by any minister to the effect that it's proposed to withdraw the current version of the national standards and reissue them in a modified form without paragraph 7?
If I may turn my head for a moment.
7.
Thank you. Unfortunately, I can't help you with that. My client is not aware of any such change, an imminent change to that effect.
Thank you.
So my learned friend places reliance upon the guidance to suggest there's an assumption of responsibility. The reasons I've given is it being a non-binding and also vague document that doesn't necessarily.
What you've done is to say it doesn't help on interpretation of the legislation, and that's a very clear submission. Understand that. But what do you say to the independent argument that, regardless of what the legislation says, there's an assumption of responsibility on the strength of this document, because on any view, creditor is defined in a way that explicitly includes HMCTS to whom financial creditors are paid, and I take it you're here effectively representing HMCTS as far as this is concerned, and this is saying what HMCTS will hold itself to. That's the argument.
My lord, assumption of responsibility, my submission, is a legal concept. It's not just pulled out of thin air in terms of here's guidance, and the guidance says we are, if it doesn't go to that effect, but the implication that we as creditor are responsible for the enforcement agent doesn't lead directly to the conclusion that there's an assumption of responsibility. The case that deals with this is Woodland and Swimming Teachers Association, which is page 716 of the authorities bundle. Apologies, 715.
No.
It's the reference to the paragraph by Lord Sumption.
715 is something else.
It's apologies. It's from Clark and Inzel, referencing Woodland. It's short. The particular paragraph in Lord Sumption, and also what Clark and Inzel have said about this just above it.
I'll start just before we get into the detail. Can I just see where you're going here? Because this section of Clark and Inzel is all about non-delegable duties.
That's correct.
But that's not the argument. The argument is not that this is a non-delegable duty. The argument is this is an assumption of responsibility.
But the reference to an assumption of responsibility, my learned friend relies upon this very case, comes in the context of non-delegable duties of care, in the context of the tort of breach of a non-delegable duty of care. Right. It's not just a concept that one can just apply to scenarios such as the one at present. It's a concept that's applied within the confines of the law.
I'm sorry, I may be misunderstanding, but I thought that Mr. Kessler was relying upon Smith and Littlewoods, which is, among other things, about assumption of responsibility, whereas Woodland and Swimming Teachers, as you rightly say, is about non-delegable duties, and that's why it's discussed in that context. And I thought these were two different concepts, but if I'm wrong, please educate me.
Smith and Littlewoods does discuss it in a slightly different context. I could start there first, then work my way back to Woodland. Let's turn to Smith and Littlewoods. Page 300 of the bundle, of the authorities bundle, the section that's relied upon by my friend. Section by Lord Goff. The first point to raise about this section before I come on to the detail is, as far as I'm aware, this section was obiter because it didn't lead to the result in the case. The case here dealt with reasonable foreseeability of loss, not these special circumstances in which a defendant may be held responsible for injury suffered by the pursuer. In that case, the court didn't need to go that far into these special circumstances or their exceptions. The court was here. Lord Goff, Goff's view was slightly different to the other leading judge. The other judge who gave the leading judgment. As the basis upon which there can be a general rule that one can be liable for the actions of third parties who come onto your property as an intruder and end up damaging your neighbour's property, for example. So it isn't binding law. And what the court there said was that there is a general rule that there isn't liability in those circumstances, but there can be exceptions. And the one referred to by my learned friend is this idea of an assumption of responsibility. But that assumption of responsibility, in my view, cannot simply come from a document, a non-binding document, or guidance. There has to be an assumption of responsibility in law. In this case, MOJ are not assuming responsibility, legally speaking. They've done it by way of a non-binding piece of guidance. There is no legal assumption of responsibility at all that I can see the MOJ have adopted. And in my submission, the assumption of responsibility isn't an assumption of responsibility towards the enforcement agent. It's an assumption of responsibility in accordance with the principle that one would owe towards the individual that's been injured, the defendant, the debtor.
But that's the argument. I mean, I take your point about the status of the document. That I understand. But why is the document not addressed to, among other parties, debtors?
Well, it's addressed to enforcement agents and their responsibilities. It's addressed, obviously, to protect debtors. I appreciate that's the aim behind it, but they're not assuming responsibility towards the debtor. They're not assuming responsibility at all in my submission, but it's not towards the debtor in any event. It's talking about the relationship between the creditor and the enforcement agent. But this particular paragraph is then is non-binding, but also it's referred to in Clark and Lindsay, where they go on to talk about what an assumption of responsibility is.
Fine.
By references, Smith was my learned friend.
Where do we find that?
Yes, it's in the section. hopefully pull it up.
Well, it tells us to whom it's addressed, doesn't it? In paragraph 1. These standards are intended for use by all enforcement agents, public and private, enforcement agencies employ them, and the major creditors who use their services. This document establishes a set of common standards to cover this activity, supporting the underpinning legislation. In order to improve the public's perception of professional enforcement agents and those who employ them, must maintain high standards of business ethics and practice. So as I understand it, these are setting out high standards of business and ethics for the agents and the major creditors who use them to abide by.
I appreciate that, my lord.
At the moment, I'm seriously struggling to understand how this assumes the responsibility on the part of the Ministry of Justice to debtors.
That's my point, my lord. It doesn't, in my view, do that. Does it assume a legal responsibility towards a debtor at all? And in my submission for the court to say, but on the basis of a non-binding guidance, which in accordance with Benyon wouldn't provide any assistance in interpretation of paragraph 66, that guidance leads to a conclusion that there's a legal assumption of responsibility on the part of the Ministry of Justice. My submission, for the reasons I've given, would be going too far. The background behind assumption of responsibility in accordance with Little was at 752 onwards of the authorities bundle. It's actually the section relied upon by my learned friend at 754. Assumption of responsibility by public authorities. None of those cases have I'll give a moment to the court to read it, 761 to 763, but in a nutshell, it says at the top, such cases are extremely fact sensitive, but as a general, it will be rare for a public authority to be found to assume responsibility to a claimant to protect them from harm caused by a third party. And the cases that are discussed, one can see the unique scenarios that are faced in those cases. And none of those is it based on non-binding guidance.
What do you say about 762 and the examples given from the medical context? And obviously the context here is rather different. But those are contexts where there's an assumption of responsibility, even though there's nothing in writing at all.
But Darnley and Croydon Health Services.
Yeah, well, that was, I think, oral information. But anyway, that's the more general point is that there can be an assumption of responsibility without necessarily even anything in writing.
I appreciate that, my lord, but as one can see, it says near the top, for example, an emergency department of an NHS hospital holds itself out to the public as willing to accept patients. This guidance, as far as it goes, it may hold itself out as saying that without prejudice the submissions are made, it only holds itself out as saying that this is what the enforcement agent needs to follow, and this is the guidance and the high standards that you must meet, but it doesn't say we are assuming responsibility for any harm caused to any debtor, and that's the distinction.
Yeah.
I
The
don't know.
question here is, if you assume for a moment, let's read paragraph 7 as saying that a creditor has legal liability for the acts of an enforcement agent. It doesn't say that. Let's assume it did say that. And that is wrong as a matter of law. Is the Ministry of Justice assuming responsibility for the acts of enforcement agents where it is the creditor, even in circumstances where it has misstated the law in guidance? That's the proposition here, isn't it? It is that they've wrongly stated the law, but by wrongly stating it, they've assumed responsibility.
I wouldn't think that is that wouldn't be the position, simply because it's wrongly stated. Again, for the reasons.
Even though they say it's not legally binding, they have bound themselves to an incorrect proposition of law.
In my submission, that's just going too far. I don't see any legal principle upon which one can back that scenario. It's a guidance. Otherwise, this could open up a floodgate to a number of guidances and claims where many come to court and say, well, this is guidance, but because they've said this is how they should be. They're now stuck with it. It could be a misinterpretation of the law. It could be a misunderstanding. In my submission, it would be going too far, my lord.
It's effectively amounting to an estoppel as to the law without any actual representation or reliance, isn't it?
Yes. That's correct, my lord. There's nothing further for me to add to assumption of responsibility other than that. Actually, one point, very quick, my learned friend, I think it was raised against my learned friend, which was this was never a case of assumption of responsibility falling outside of paragraph 66, is what he said. That wasn't the case before the lower courts at all. Assumption of responsibility is a new pleaded point before your lordships and lordship today in the Court of Appeal. It wasn't a point raised in lower courts. And here we are talking, if we talk about the strict confines of the grounds of appeal, about paragraph 66. I'll double check this a little further for me on ground 1 before I move on to ground 2. Just picking up a few points raised by my learned friend as the last few points. He suggested that there could be a case where if there was lost, if a creditor was to be held liable, he can claim an indemnity contribution from the enforcement agent. In the context of paragraph 66 application, it's an application. Part 84 of the CPR makes clear that any paragraph 66 application must be made by way of an N244. If there was a contribution made, it just does not fit neatly within the confines of the CPR, because the CPR requires a claim for a contribution indemnity to be a Part 20 additional claim. So how can that fit in with an application being made under Part 23?
But we're not in the CPR at all, are we here? And is it your submission that the Act is inapplicable?
The Act is in... I might have lost you there, my lord.
I forget whichever Act it is that deals with contribution indemnity. It's dealt with.
It is within the CPR, within the confines of the CPR, because Part 84 requires paragraph 66 application to be made by way of an N244. It doesn't say otherwise, like by way of a Part 7 or Part 8 claim, for example. I can take...
So paragraph 66 is referred to in
in Part
CPR
84 of the CPR.
What do you rely upon, Mr. Trivedi?
Let me just locate it myself.
So-
It's definitely there. It's
But-
definitely my
To
lady.
go back to the question I was asking for, is this not dealt with by the Civil Liability Contribution Act 1978? Because I understood that to be what was being relied upon. Now, are you submitting that there is some inapplicability of the Act by virtue of the procedure that's required for paragraph 66?
I wouldn't be able to say that the Act doesn't apply. I appreciate that, my lord. But
Right.
Procedurally doesn't fit in is what it would be my submission. So it would be quite unique for the procedure to have been different to the way envisaged if there was to be indemnity or contribution applied to liability.
And what were you looking for in CPR 84?
Bear with me, my lady. I did have the paragraph, but I seem to have lost it. It's page 2514 of the 2014 White Book, Rule 84.13.
Again, I don't have it in front of me, so you'll have to read it to me.
This rule applies where the debtor wishes to bring proceedings under paragraph 66 for a breach of the provision of Schedule 12. The debtor may bring proceedings by way of an application, and it must be accompanied by evidence of how, and it sets out what evidence is required, and then it goes on to, by way of the reference to the other rules, and the commentary as well, confirm that the application is by way of an application to Part 23, N244, at 84.13.1 of the White Book.
Thank you.
So procedurally doesn't seem to fit in with my submission. My last point on ground one was the DCLG guidance. I appreciate what it says, but the same reasons given to the national guidance. It's non-binding. It's by another local authority. It's not by the Ministry of Justice. And it's not entirely clear if it is, that whilst it is pre-2014, whether or not consideration was given to the changing landscape of the law. My other friend suggests it was, but we haven't seen anything to that effect. And I would submit, therefore, not much reliance should be placed on that document. With your permission, the court's permission, may I move on to ground two?
Yes, do.
Thank you. In respect of ground two, I don't believe, well, I can just turn to it. I said my submission's out of paragraph 42A onwards of my skeleton. The first point about the response to my learned friend submissions about Beechwood, I do concede that I can't get away from that. So I can move swiftly on from the principle in Beechwood. I do have two submissions to make, one in respect of special damages, and one in respect of the respondent's notice about the substitution of the measure of loss where there's a claim for mitigation expenses. In respect of special damages, I deal with that paragraph 42D. The first point is, if one looks at the grounds of appeal, it's only in relation to general damages. There is no additional ground of appeal made in respect of specials.
The appeal covers both, doesn't it?
You'll find the grounds at page 14 of the core bundle.
Yeah. And it's entirely general.
That's right. It's only the Beechwood case.
Yes, but he's relying upon Beechwood as supporting him on both general damages and special damages. It's specifically for saying he can claim both. So where do you say that paragraph 2 is limited to general damages?
I took that Beechwood only dealt with the question of the measure of loss for general damages.
But his
but not
skeleton
special
argument,
damages.
which was served contemporaneously with the grounds of appeal, made it plain he was appealing both, didn't it?
I'll move on from the point. In terms of special damages, I would still submit that evidence and proof must still be shown with particularity as one would require for its pleading. It should consist of evidence of particular losses. And I get that from McGregor and Damages, which is in the authorities bundle.
Sorry, you want general damages or special damages?
Special damages.
Right. Okay.
In terms of the test that arrives from Beechwood, I appreciate that there is a mechanism on low value cases to provide for a figure for that without insisting on specific evidence, as it says.
Right, so what is your submission on general damages, apart from the point which I understand that you say that in circumstances such as this case, the claim for special damages effectively substitutes for it? Have you got any other submission apart from that?
Yes, and it's on special damages, and that's what I have. The first
No,
submission
on
was.
general damages, have you got any other
There's nothing further on general damages.
Thank you.
It's the requirement for proof for special damages. That's the first submission.
So forgive me, you don't dispute the £25 figure then?
No. There is I'll come on to a moment in terms of how one can, how the Court of Appeal will be able to decipher what the figure should look like, but I'll come on to that at the end, because the evidence appears to be very vague indeed. So whilst I accept £25 per day as a figure, I don't necessarily accept that it could apply to the entire period in question, because it's not clear when the appellant was able to mitigate his loss, what days he actually took buses, etc.
Yeah, well, as you say, that's a separate point.
That's right.
But can I just ask you this question? Is it your submission, having regard to what you said already, that assuming Mr. Burton prevails on ground 1, of course you've given us lots of reasons why you say he shouldn't, but assuming Mr. Burton prevails on ground 1, do you maintain that the correct order is 0 damages? Because it rather seems to follow from what you've conceded so far that there can't realistically be an order for 0 damages.
No, I appreciate there can't be an order for 0 damages.
Okay, thank you.
The amount is disputed, but definitely would not look like 0. It would be.
But we're now just arguing about the 180 at the moment, are we?
Yes. So as referred to, McGregor and Damages deals with the point about evidence and proof of special damages. It's at page 849 of the authorities bundle. And it's 52016. Therefore, it normally consists of evidence of particular losses, such as the loss of specific class of specific contracts. Here there was nothing.
I'm sorry, it's my fault, but I don't seem to be on the right page. Can you give me the page again?
849, my lord. Of the authorities bundle.
Yes, and which paragraph?
52016.
Thank you.
I'm sure the court's aware that, generally speaking, that is the position when it comes to special damages. When one pleads it, there has to be particularity. When one tries to prove it, there has to be sufficient evidence. Here, in this case, we have the witness statement. I appreciate that is evidence, but we have nothing further in support. In my submission, it was...
Sorry, what's lacking by way of particularity? He particularises the sum spent, and he particularises what he was spent on, at least in general terms. So what's wrong with that?
It's the same point. There is no, in support of what the lower court found, there was no evidence in support of it by way of receipts.
So you're saying that his evidence is to be disbelieved?
I wouldn't say disbelieved. Of course, I can't say that. There wasn't a cross-examination.
And he wasn't asked for receipts either?
Sorry,
he was not asked for receipts either?
I appreciate that, my lord. But the rule is there as to the particularity of losses, and I would rely upon that. My friend, I do not know if he has taken the point. I don't believe he did in his submissions about the insurance premiums. That doesn't find itself.
No, he said he wouldn't pursue that.
So I'll move from that. Nominal damages was pursued. My submissions there at subparagraph G of paragraph 42. The argument is essentially there was no claim for the claim was not framed as one for nominal damages, suggesting that there was a trespass and therefore that's actionable per se, leading to nominal damages at all. And we know what paragraph 66 says in that respect. That one is not a trespasser for a breach of Schedule 12.
Well, before we get into the question of nominal damages, could I just go back to what you were saying? I understand your point on special damages. It's the point you've made. You say there's no particularity. Can we just assume that we're against you on that? And suppose we say, well, there's sufficient evidence of special damages of £180. You make the point, which I fully understand, and we explored it with Mr. Kessler, that you can't have duplication. Mr. Kessler's answer to that was to say, well, there isn't duplication, because he says the special damages claimed are pecuniary losses, whereas the general damages claimed are non-pecuniary losses. That's simplifying his argument, but I think it's adequate for present purposes. What's your answer to that?
That's where the respondent's notice comes into play, my lord. The substitution of the measure where there is a claim for mitigation expenses, such as the expenses said to be incurred by Mr. Burton. Turning to the respondent's notice to address that, the references to the Lagdon case and the binding decision of the judgment is paragraph 27 of that judgment.
Sorry, where is that in the bundle?
It is 324 and 325. It was referred to by my learned friend, but I have a different interpretation to it.
We're at paragraph 27, yes?
Yes. The judge stated that Mr. Lagdon's claim was a claim for the loss of use of his car while undergoing repair. There was no evidence that he would have suffered financial loss as a result of being unable to use his car. In this case, there was, if one accepts the special damages claim, on the basis of what my lord stated. But the inconvenience is another form of loss for which, in principle, damages are recoverable. I accept that. So it's open to him, to any other motorist, to avoid or mitigate that loss by hiring another vehicle. The expense of doing so will then become the measure of the loss which he has sustained under this head of his claim. That's what I rely upon.
Well, okay, but how does that work in present circumstances where Mr. Burton didn't hire another car? Obviously, if you hire a car, then your loss of amenity from your own car is fully dealt with. But if you don't hire a car, but instead rely upon occasionally getting buses, and when you really need to, you hire a taxi instead, how is the loss of the use of your own car fully compensated for?
I appreciate it may not be fully compensated for, but
Right.
There is an element of overlap in any event.
So you would say that therefore the award of general damages should be reduced, but maybe not eliminated altogether?
That would be one point there. Yes, my lord. That would be the position.
Right.
There has to be a reduction to reflect otherwise there would be a duplication.
Well, the more you spend on mitigating your loss of amenity, the less your loss of amenity
is.
That's all it amounts to, isn't it?
That's right. So to extinguish, or at least go towards extinguishing the general damages that are being claimed. But the difficulty the court has in this case is a couple of paragraphs of the witness statement. And I can turn to those paragraphs because that was the the final issue on damages that I had, I think it's page 8 of the supplementary bundle. We see paragraph 26, 27. I believe my friend raised the point that, correct me if I'm mistaken, that the £180 didn't reflect the entire period in question. But when one looks at those paragraphs, there's no breakdown of the period of the £180 as to when that was spent.
What's the last week, isn't it?
Well, the last 2 weeks. I think it's the 14 days that's referred to in paragraph 26, isn't it?
Especially, I claim £180 for the amount I've had to pay out since my car was clamped for public transport and cabs. I don't believe there is a particular period that's given.
Yeah, I mean, the week comes from paragraph 23, so there is an ambiguity there.
But 26 is expressly, I claim 180 for the amount I have had to pay out since my car was clamped.
Yeah.
Mm-hmm.
That is a period.
I appreciate it. What I would also say is how one then deducts £25 the figure of £25 per day in general damage to reflect the £180 spent. That's not entirely clear. I don't believe these points are being pursued. The £10.88 per day for any extra days the car remains clamped.
Well, it's the 88 pence that's not being pursued.
The £10.88, that figure doesn't, but where that figure comes from, one does not know. How that relates back to the £25 per day. One doesn't know the period the car remained clamped either. And there's a figure that's given in the appellant's notice.
We do know how long it was clamped, don't we? Because we know when it was clamped and we know when it was ordered to be taken off. So what's the problem with that?
There was an injunction order that required the removal of the clamp, but it's not entirely clear from my reading, at least of the bundle.
So we know that the clamp was applied on the 22nd of January 2021. The order for removal was the 15th of February. We're not told that it was given effect to the same day, but it's in your client's interest to assume that it was.
Absolutely.
Right.
But there is a figure that's given for the amount that should be awarded in the appellant's notice. Well, I believe it's around £1,000, but it's not entirely clear how that's made up. But that's a question for my learned friend, really. There's nothing further for me to add.
One thing's for certain, the amount of any damages which, if any, were awarded would be dwarfed by the costs. Would be dwarfed by the costs.
I completely accept that, my lord. I believe that is everything from me, unless there are any further questions.
Thank you very much indeed. Mr. Kessler, do you have any reply?
Yes, a short reply, although it will be brief because lots of the points I would have made have already been aired in argument. I thought I'd start with the question of damages. Ground 2, and then I'll move back onto ground 1. This is quite a strange case. Terribly low value, litigated in the county court in Hull. And from what I can tell, ground 2 has at least in part been conceded. But I thought I would answer the question of how the figure of £1,040.52 was calculated, since my learned friend asked me to. It's because there were 29 days in which that the car was clamped. You'd actually have to make an adjustment for the 88 pence per day. I've conceded that.
So what were the 29 days?
29 days was the days in which the car was clamped. And so that's how the figure was calculated. 29 days at £35.88 per day.
So forgive me, I thought we just established that it was clamped on the 22nd of January.
I need to check my chronology, but that is familiar.
29 days must be on the basis that it was not declamped on the 15th.
Yes.
So where is the evidence as to when it was declamped then?
I think it was done by way of submission rather because all the evidence was filed with the application and the application sought to be declamped. So there wasn't a follow-up witness statement filed for the remaining days, how many there would be. Lost count. So it's not an evidence, it's only an argument.
I know, but can you point to
I can point to where it is an argument.
where we can find
It's
it?
in the supplemental bundle, page 158. I didn't write down the tab number.
It's tab 19.
So this is the skeleton argument at the hearing. And it's paragraph 27 on page 158.
But that's just your 29 days and the £35.88 includes the 88p
It
per
does
day.
indeed, yes. So one would need to deduct 29 times 0.88.
And the 35 is 25 plus
10. And 10 is the £180, which he suffered £180 worth of special damages using buses and taxis over those 2 weeks. And he said, well, it's going to be another £10 a day or so, based on his experience of the first 2 weeks of having his car clamped.
Oh, so it's not £180 at all.
Whereas £180
Plus.
Yes, and then inferred to the future, £10 a day. Yeah. And the alternative, my lady, would have been to file an update witness statement at the date of the hearing.
So we're told at paragraph 11
Yes.
the vehicle was released from the clamp on the 19th of February.
Ah, thank you. So 4 days later. Thank you.
Well, that's then. That is then 25 days, not 29 days.
Then what's gone wrong with the arithmetic? It may be the fact that it was 180, which is £13 a day, technically speaking, for the first 14 days, and then £10 a day thereafter. I don't want to take up too much of the court's time on this because it is not an important point of principle. I'm sure.
I'm just not quite sure how we're going to actually, but we do have to work it out. Don't we?
Well,
if we're going to allow your appeal
yes.
and make an order, we have to do it properly.
Well, it may
Yes.
be that it's inclusive because the vehicle was clamped at around 10:20 on the 22nd of January. And if it was not clamped until, let's say, the afternoon of the 19th, then it may be the calculation is done by including both those dates.
Yes. Thank you for that.
That's still 24 days or 25 days at best. In any event.
No, I think it's about 28 actually, but never mind.
Anyhow,
I'm happy to concede if it's 28. This is not
How many days? I see this.
31 in
Right.
That's ground 2. Back to ground 1. 2 things to say. One about the national standards, and the other another comment. A comment made in argument. I'll start with national standards. If the court could take it up, it's behind the back of the authorities bundle. Behind tab 48. Two quick observations. The first is, in the argument during my submissions, the point was raised again by my learned friend. It was put to me that this guidance only applies to major creditors. I thought I would draw the court's attention to the fact it applies to intended for use for all enforcement agents. And so all enforcement agents reading this are thinking to themselves, who am I acting on behalf of? So not only should creditors remember enforcement agents are acting on their behalf, but all enforcement agents are being told this as well. So it's not that limited in its extent, because by definition every creditor has to use an enforcement agent. So someone on that process has to read this document. That was the first thing. And the second was there was a suggestion in argument that what exactly are creditors responsible for? It's only responsible for ensuring that the enforcement agents meet the high standards set out in this document. And I think that's true for some of these points, and some of them I think are purely conduct points. Paragraph 26, for example, enforcement agents must carry out their duties in a professional, calm and dignified manner. They must dress and speak appropriately. Pure conduct point. But they're not all pure conduct points. Paragraph 19, for example, says enforcement agents must act within the law at all times, including all legislation. And plainly that refers, among other documents, among others, legislation to Schedule 12. Schedule 12 is the main piece of legislation that determines how enforcement agents should act. So you can construe paragraph 7 as saying you must be responsible and accountable for everything in this document. Everything in this document incorporates Schedule 12 via paragraph 19. And the very last thing to say, it's a small point, but it comes down to these chains of contracts that I mentioned as being the way in which the creditor can control the enforcement agent. And it was suggested that while major creditors, MOJ, local authorities will have contracts, your average judgment creditor who obtains a low-value judgment debt wouldn't. I don't think that's right, because obviously that's a matter of evidence, but you think about the legal analysis, there is consideration going each way. The judgment creditor does have to pick an enforcement agent. That enforcement agent is going to get paid by the fees regulations for the work that they do. So it strikes me as very likely that there would be some contract of some form. Now, I could well believe that the average judgment creditor isn't going to read the contract. It's conceivable it's an oral contract that would exist within the legislation as a possibility. But there must be a contract, because there is consideration going forward each way. I'm not sure a creditor could capriciously ask an enforcement agent on one day to act, and then on day number 2 say, no, we're not contractually bound. I'll ask a different one to act. There must be a contract in basically every situation.
Well, yes. I mean, let's assume for a moment you're right about that. But if that's all that one has, what does that really add? Because you make the point that as between creditor and enforcement agent, if the debtor claims against the creditor, then there can be contribution or indemnity under the Act. And from that perspective, why does it matter whether there's a contract or not? If you're right, what does a contract add? And if you're wrong, how does it help you?
Well, this all... So the way I pitch this case, I frame this case is that this is a question of construction of paragraph 66.
Quite.
And the question is it absurd to say paragraph 66 holds creditors strictly liable, even though they might not have contributed to the loss? And one reason it is less absurd is because there is a mechanism, it's outside of the Act, which will, in my submission, nearly always apply in some form, for creditors to control the acts of the enforcement agent. That's how it feeds in.
Right. So it's just it's reinforcing your submission on that point. Yeah.
Yes, exactly. And those were the points I wanted to raise in reply, unless there was anything else.
Thank you very much indeed,
Thank
Mr. Kessler. Thank you to both of you and to those behind you for preparing this case for us today. As you will appreciate, to start with, we will reserve our judgments, and as you appreciate, in this court, judgments are sent out in draft. They are sent out for correction of obvious typographical errors and factual errors, but not for re-argument, and therefore we expect and encourage short, not submissions, but at least references back in relation to those obvious errors and obvious errors only. I also ought to remind you about the embargo on those drafts when they go out, and be very careful about that. And you should have submitted already the list of email addresses of those who are within the circle to receive the embargoed drafts. You'll also be fully aware, no doubt, that we hope that you will be able to agree an order in relation to consequential matters once you have seen the drafts. And if you cannot, that in this court those matters are dealt with on paper, and we would ask you to submit short, by which I mean short, submissions as to why you disagree with each other about the form of the ultimate order. I think that's it. Thank you very much indeed.
All right.